All right. I think we're live now, and we're being heard over the Etherland. So I want to take a moment and welcome everybody. This is the first of our 6-part masterclass for real estate agents and other professionals, real estate or otherwise. My name is Scott Marcus. I'm a real estate attorney with Becker and Polashuk, and also with Becker Title. I'm joined by my law partner, Elana Polashuk, and both of us are hosting today, and we are joined by a very special guest, Isaac Salver, CPA with Salver and Salver. Isaac, how the heck are you?
I'm doing great. It's
Wonderful.
great to be in between two great professionals here.
Excellent, excellent. Today we're going to be talking about FIRPTA, which is a portion of the Tax Act, and Isaac's job and Elana and my job is to attempt to make tax fun and understandable to all. So let's talk a little bit about Isaac first. All right, Isaac graduated from FSU with his undergrad degree in finance. He then went on to get an MBA from Hofstra. Became a CPA in 1985, established his practice in 87. Completed his first FIRPTA application in 1997, and then Behi, his wife, joined his practice, and she is the FIRPTA manager of the practice. That occurred in 2002. Salver and Salver was established when Seth Salver joined in 2015. And as of 2016, Isaac reached a milestone of handling over 150 FIRPTA cases per year. That's correct, Isaac, right?
Yes, sir.
Wow.
Okay. So what we're going to do today is we're going to have the topics of discussion being FIRPTA, the Foreign Investor in Real Property Tax Act, with the mindset that most of our audience are real estate agents, and we're trying to impart upon them practical tools for handling these not so easy to understand topics. Okay, so we're going to do an introduction to FIRPTA. We're going to talk about who is subject to FIRPTA, how FIRPTA affects real estate transactions, what the application process looks like. We're going to then get into some real world scenarios, some examples, and then leave off with important topics to note. So, Isaac, I ask of you, what is FIRPTA?
FIRPTA is an acronym. It's the Foreign Investment in Real Property Tax Act. It was passed by Congress in 1980. And it was passed around the time, the mindset of Congress when they passed this legislation was that there were foreign individuals that would come in to the United States, or just, inbound investment in the United States. And prior to 1980, there was no law that required any accountability on behalf of the foreign investors. So FIRPTA was developed specifically targeted towards real estate investment and kind of handcuffs foreign investors to a compliance process by which the government gets withholding tax from any proceeds the foreigner gets from selling real property. And it wasn't until, I would say, the mid-90s that the Treasury Department really got their act together, established the proper procedures, and really started enforcing the FIRPTA Act.
So in summary, FIRPTA is a way that the U.S. government captures tax revenue from foreigners when they purchase and sell real property that falls under the act, correct?
That is correct, but just to refine your comments a bit, it is not a tax, it is a withholding. Okay. So it's a withholding. That's very, very important, because oftentimes folks are misled. They're saying, oh, this is a tax. It's not a tax. It's a withholding that gets credited to the seller of real property.
Understood. Okay, so there are transactions that are subject to FIRPTA, are under the banner of dispositions of US real property interest by a foreign person. Let's break those down. Dispositions, what are we talking about dispositions?
Okay, dispositions can take a few forms. Obviously, the most common form of disposition is a sale, an arm's length transaction between two parties. But it could also be a transfer of property, you know, a swap. Swaps are subject to FIRPTA, and also any type of deed, anytime a property is deeded from a foreign individual to someone else, those types of transactions are also subject to FIRPTA reporting.
Okay. So in our real estate world, we have within our contract, we have FIRPTA provisions, and we'll talk about that. But we also, on a regular basis, go through, we get phone calls, Elana and I, where an individual might just want to transfer property, quitclaim deed a property from A to B, and that individual is a foreigner and a non-US taxpayer. So that could be considered a transfer. Is that
That is correct. Depending on the overall structure, you know, yes, that would qualify in most circumstances.
Okay. So we've got a disposition. We talked about that, a sale or a transfer in US real property interest. So let's break down what US real property interests are.
Well, a US real property interest could be a direct ownership.
Okay.
In real property, you know, a fee simple type of ownership, or the ownership of an LLC that owns real property. In certain circumstances, let's say. So,
okay, and so we've got the disposition of U.S. property interest, sale or transfer of property, where you either own the property or you're doing a transfer, an ownership interest in a limited liability company that owns the real property by a foreign person. So the foreign person part is the last component of transactions that are subject to FIRPTA. How would we talk about foreign persons, Isaac?
A foreign person could be an individual, a natural person. It could be a trust.
Okay.
And it could be a foreign trust, of course, or a foreign corporation.
Okay. And does the U.S. tax code treat foreign individuals the same as your immigration tax laws, or is it a little different?
It is a little bit different. The IRS has their own set of rules as to how to determine whether an individual is a U.S. person or a non-U.S. person. And although there are some, slight overlap, I like to describe the difference as two parallel systems. They don't really, they don't always coincide with one another. So the short answer is the IRS has their own rules and regulations regarding who is a U.S. person and who is a foreign person.
Okay. So we just spoke about transactions which are subject to FIRPTA. We're now going to talk about who is subject to FIRPTA and break it down by categories. And the way that I believe we look at this, Isaac, is if a seller is an individual, they could fall under a couple of different categories and be subject to FIRPTA. Could we talk about those categories that fall under individuals?
Yes. An individual that, a foreign individual can be considered someone that is, has not been to the United States or only spent a few days in the United States. Or there are certain types of, visas that are offered to foreigners that would not qualify them as resident aliens. So a non-resident alien is considered a foreign individual. And
so we're talking about not a US citizen or resident first, but then we've also got some other tests where substantial presence comes in, that somebody could or could not be a foreign person or an individual by definition for FIRPTA. Is that correct?
that's correct. And here's where, here's where the immigration laws and the tax laws diverge from one another, because there are certain presence tests that, if met, would require an individual to file as a resident, where they really have no status in the immigration system.
Okay. So just because I'm not as smart as you, or am I as smart as Elana, I like to think, okay, so if we're not a US citizen or resident, we're going to be considered a foreigner for the subject of FIRPTA. There are some limited differences or alternatives. That's on the individual side. The limited liability company side is really interesting. Elana, don't you agree? Because on the limited liability company side, Elana, we have real estate transactions all the time that we've got a limited liability company property owner, and that property and that transaction, all people believe that transaction is not subject to FIRPTA, because that transaction or that limited liability company is a Florida LLC, but that might not be the case. And Elana, we've seen many occasions where that's not the case, right?
We've seen many circumstances where it's a Florida LLC, but the members are foreign. We've seen a Florida LLC that is managed by a Delaware LLC, has a foreign member, manager of that Delaware LLC is foreign. And in some circumstances, if the LLC elects the proper designation for filing their taxes, it can be an exception and not subject to the FIRPTA withholding, but there's just a lot of digging and due diligence, and Isaac will get into all of the fun stuff with LLCs shortly. But
yeah, so you hit upon a very good point. When we're talking about limited liability companies, a lot of foreigners will take title to real property in an LLC, and they will do so under the prompting of maybe an attorney. And it is not necessarily a wrong thing to do, and in fact could be the right thing to do. However, when that LLC, an LLC has members, and if that LLC only has one member, it's called a single member LLC. And if that single member is a foreigner, right, Isaac, then that LLC just serves as a pass-through, just a funnel. And that Florida LLC is the person at the end, the single member that's a foreigner, is subject to FIRPTA, correct?
Right. And, again, the nomenclature is kind of important here. The IRS refers to a single member LLC as a disregarded entity.
Okay.
And if a foreign individual or a non-US person owns an LLC solely, a sole owner, then since the LLC is disregarded for tax purposes, the entity will be taxed using the character of its owner. So if the owner is an individual or a foreign individual, it'll have, all the obligations of a foreign individual without regard to the Florida LLC.
Very important, because a lot of times our real estate agents go out on listing appointments and they're doing a listing presentation. They're looking to capture a listing, and the property is held in a Florida limited liability company. And FIRPTA does not come up until we, as the real estate attorneys, send out a questionnaire. And as part of the questionnaire, we determine that the LLC is a single member LLC, and that person that is that single member is foreign. And therefore, we are now post the listing process, post the contract process, and we're into a FIRPTA related issue. So I think it's very important for our viewing audience to understand that a domestic LLC does not necessarily mean that we are avoiding FIRPTA. However, if we have a single member LLC, there's a tax designation, correct, Isaac, that the single member can do to be treated differently?
Yes, there is an election that is made on behalf of the LLC, signed by the shareholder or shareholders of the LLC, that enables them to be taxed as a domestic corporation.
Okay, that's important because now we've got an LLC, a single member LLC that's a disregarded entity. However, it is being taxed as a corporation. So it is paying US taxes for the purposes of our scenario here and would not be then subject to FIRPTA. I think it's an 8832 filing.
Yes, that's correct. And you know, that unwinds the disregarded entity element of an LLC, which is the default. You know, a single member LLC by default is a disregarded entity. And that entity, if it makes the proper election, you know, files the entity's, the entity election form and elects to become taxed as a corporation, it is no longer disregarded, and it's regarded as a corporation. It's taxed as a corporation, you know, with all, you know, the benefits, you know, and obligations that go along with it.
Perfect. Okay. So right now we're talking about the heading of who is subject to FIRPTA. We've talked about individuals. We've talked about limited liability companies, corporations. What about corporations? I think if they're organized outside the US, or how does that work?
Right. Corporations, if a corporation is a US corporation, I would say, 95% of the time, almost all the time, they're outside of the FIRPTA regulations.
Okay.
They're not required to comply with FIRPTA. A corporation that's established outside of the United States is required to comply with the laws of FIRPTA.
Okay. So outside the United States, non-domestic foreign corps, FIRPTA then would apply, and also foreign trusts. So that wraps up the bracket of who is subject to FIRPTA in the categories. I want to talk briefly with Elana and loop her in, because, the interesting thing we see as attorneys, Isaac, is when we're handling a transaction, all of the information that we need about FIRPTA, or most of it, comes from the seller. But the person obligated for this information, right, Elana? We've got the buyer, correct? So it's a buyer liability. Yeah. I think, Isaac, if I'm not mistaken, they set up buyer liability from FIRPTA because they have to make a party responsible, and they figure who better than make the buyer responsible for the FIRPTA withholding? Or would you say there's another reason?
Well, first of all, this is a very unusual code section, the way it is written, regarding, code section 1445 regarding FIRPTA withholding, because this is one of the only tax schemes that is imposed by the Treasury Department that actually requires withholding of one party's funds to remove liability from another party. But it's so odd the way the code is written in this case, because it says it's the buyer's responsibility to make sure that the FIRPTA funds are remitted. So it's almost like a buyer's, the buyer's responsibility, but the funds that are being remitted are the seller's funds. So this is only like a commentary or an opinion that once the seller, it's important because it's important to loop in, have the buyer have some responsibility here, because if the seller succeeds in not complying with the FIRPTA requirements, the buyer's property is at risk of lien or levy by the government for unfulfilled FIRPTA liabilities.
Okay.
Okay, so it's kind of low-lying fruit for the IRS to come in and says, make sure, if you're a buyer of real property from a foreigner, you better make sure that the FIRPTA is taken care of here, because you can lose your property.
Yeah, and that is absolutely critical, because in any of our purchase contracts, we've got the two-party system, the buyer and the seller, and we now see the reason for the importance of both parties working together properly under the appropriate guidance of professionals when it comes to FIRPTA, because buyer will have liability, but it's a seller, it's the seller's money. So this is why contractually there are provisions in our contract regarding FIRPTA and how those sort out. And we're gonna give you a little tricks of the trade at the end.
And just to jump in, it is a seller obligation to disclose that they're a foreign person subject to FIRPTA. So that disclosure is required in the contract by the seller.
That's another great point, because a lot of times I think a lot of times we're faced with sellers who are not aware whether or not they're subject to FIRPTA, or they think because they're in a domestic company or a domestic limited liability company that they are not subject to FIRPTA, and the rules don't apply to them. And it's only after we educate them, and this happens so often, that they scramble and attempt to then mitigate their downside. So we've talked a little bit about transactions subject to FIRPTA. We've talked about who is subject to FIRPTA and who's responsible. Now we're going to get into how FIRPTA affects real estate transactions. So this is under the heading of your transaction falls under FIRPTA. And I want to hear from Isaac a little bit about the remittances or the withholding and escrow. I think there's two ways things could go, right, Isaac? We can either remit or withhold and escrow, and those are important. Right.
Once it's determined that a real estate transaction is subject to FIRPTA, there's an effect. There's a couple of roads that you can go down. And I'll start from the top. The most general rule, and anybody that Googles FIRPTA, what is it going to say? It's going to say that 15% of the gross selling price of a piece of real property that's sold by a non-resident should be withheld and remitted to the government.
Okay.
That's the Bible. That's the biblical passage. 15% of gross proceeds gets withheld, or it gets remitted to the government within 20 days of the transaction.
Okay.
Then
some of those exceptions now.
Right, and then like my job, I guess all my experience is I guess is built up to be able to navigate the parties in a real estate transaction through what the exceptions might be, how we can, benefit, all the parties in this, maybe reducing the required withholding from 15 to 10%, still remitting the funds, or reducing it to 10% and withholding the funds, depending on what path we take. But generally, there are two outcomes after a real estate transaction, where a foreigner sells real property. 15% is withheld on the HUD and sent to the government, or the foreign seller has an opportunity to apply for a reduction of that 15% withholding, and that's outcome B.
So this is very important, because a lot of our agents deal in some very high-end properties, and if we're talking about $1 million property, that is the price, the sale price from which you are basing the 15% on, correct, Isaac?
Absolutely. It's gross
Not on the
selling price.
net to the seller. It's not on what the buyer, what the buyer's cash to close is. It is the sale price of $1 million. And in that instance, 15%, what, $150,000 is being, has to be dealt with in some manner, shape, or form. Whether that 15% is sent to the IRS, and nobody wants that. The foreign investor does not want that. They certainly do not want to learn about that from us as the closing attorney. They would rather know upfront from the real estate agents that are at the listing appointment, that now are armed with a degree of information that, guys, I think you might have a tax implication here, and you need to talk to Isaac Salver. And that's all that's the goal of what Elana and I are trying to bring to the forefront. We're educating the real estate agents in order so that when they're out in the field, they know enough to say, red flag. Okay. When they see LLC, they ask, single member, or do you have multiple members? Okay. Or where, if they see a individual person, where are you from? Where are you a resident of? So you were talking about two paths, Isaac. We've got the remittance path that nobody wants, and we've got the withholding path. Tell us a little bit about the withholding and escrow path.
Okay. It's funny. Let me just double back to what you just said.
Sure.
The remittance path, which nobody wants. I would say 50% of the crowd, sometimes they just say remit, on the other side of the transaction, or a title company. A title company wants nothing more than to collect the money and remit it. Believe me. Okay. So, but let me talk a little bit about, the blood and guts of what we do, which is filing for a reduction of the withholding. And, first of all, the government does provide a method by which a foreign seller can apply for a reduction of the 15% FIRPTA withholding. It involves a tax form that's filled out that includes certain information about the cost price and the selling price. And basically, it's representations that are made that need to be corroborated along with the application that show, hey, IRS, we're either making very little money or we're losing money on this transaction. Please give us relief from this 15% of gross selling price withholding. And, we have proof of what we're claiming. And as long as all that is sent in, registered mail, return receipt requested on or before the closing, it could be right up to the closing date. As long as that's filed, then the escrow agent or the closing agent or the title company, whoever's doing this transaction, has the legal right to keep the FIRPTA withholding in escrow well beyond the 20 days, until which time the IRS responds to that application for reduction.
Perfect.
And we're actually talking about 18V III of the contract. 18V3 of the contract has the two options for buyer, either to send the money directly to the IRS or to keep the withholding funds in escrow.
Tell us a little bit about that section, because that's interesting, Elana. That section is interesting because it does give the buyer's side the option to do a certain act, either remit or withhold, right? And if we're on the selling side, or our brokers are on the listing side of transactions, what is that section that we want them to look at? It's in where?
18V3. So basically, if I'm a listing agent representing a seller and I get an offer from a buyer, you need to know upfront at that point whether or not your client is going to be applying for a reduced withholding. If they are, then take a look at that section, and you're going to want to eliminate option A, which is the option where the buyer remits directly to the IRS immediately and does not wait for that withholding certificate to be issued by the IRS.
Okay, critical point, and Elana, that's brilliant. I thank you for bringing that up. So our agents are going to want to look in the 18 section. I think it's Romanet 5, you were saying, and it's A or B.
18V3, and it's option A.
Okay, all right. And that option would be eliminated. The remittance option would be eliminated so that their seller, the one that they have the listing for, can withhold in escrow without contractual violation there. So that's a great point. That's how the legal ties in with the tax, and you know, I'm really glad you brought that up. So we've talked about who is subject to, we've talked about the transactions that are subject to, we've talked about the 15% rule as a general, and there's also this option of withholding. Let's talk a little bit about transactions that might be exempt, Isaac.
Okay.
And I think it goes by price. And if you could kind of walk us through maybe the sliding scale of prices of sale prices.
Scott, let me introduce this subject with talking. Now we're going to talk. We talked a lot about the seller, the property, the seller's property, the seller, who's foreign here. We're going to need to start talking about the buyer. Okay. Because the buyer, the buyer's intended use of the property that he's buying, or he or she is buying, or they are buying, could dictate some very, very material things that affect the seller here. So if the buyer is intending to use the property as as a residence, okay, it doesn't have to be primary residence, it doesn't even have to be second residence. If the buyer is intending to use the property as a residence, then there are certain there's certain reductions, reductions of FIRPTA, certain opportunities that are available to the seller to reduce the impact of FIRPTA. So, we'll go, I have a little chart here in front of me. I know that we don't have it on the board, but, if, let's say if the intended use is as a residence, by the buyer, and the selling price is less than $300,000 or $300,000 or less, 300,000 is included. So in that case, the transaction could be exempt from FIRPTA.
Okay. So pause there for a second for our real estate community. They are listing a property and the sales price is $280,000, and their seller is foreign. It's Franz from Germany, and they're not a U.S. resident, not a U.S. taxpayer. They then could very well be completely exempt from FIRPTA at that price point if the buyer is utilizing that property as a residence, correct? Or
that is correct. That is correct. And there's not, it's not even complicated. There's not a lot of interpretation required.
Right. An affidavit gets signed, right, Elana? I think we submit those affidavits to the buyer of their intent to utilize the property.
Yes. And Isaac, tell us a little bit about what the intent to reside means in this.
Okay, so we can talk about that now, because it gets, it could get a little complicated, and it's often misinterpreted, by the parties involved, by agents, even title companies. Residency means that, the first, I guess the first stroke is that we're going to live in it as our home, fine. There's no problem with that, residency affidavit. Now, the law says that an individual buyer that has the intention of acquiring a property to occupy it more than 50% of the time that it's occupied, that buyer can also sign an affidavit of residency. So, that the length of time that's measured has to be 2 years, 24 months after the closing. So if it's the intent of the buyer to occupy the property, 50% of the time plus 1 day, they are eligible to sign an affidavit of residency.
Intent to occupy 50% of the time that it actually is occupied. So by way of example, we're not talking about within a 2-year period that it has to be occupied at least for a year. We're talking about something completely different that might be a minuscule amount of time, right? Isaac, give us an example of a scenario.
Let's say I have a ski chalet in Aspen. Okay. And it's, there are no summer activities anywhere around there, but in winter it is, kicking. So it's really only occupied for about, let's say, a 4-month ski period. And the rest of the time, it lays fallow. Okay. So for 4 months during ski season, I have a piece of property. For 2 months in a day, I have me, my family, my kids, my grandkids, anybody that wants to go to the ski chalet. If they occupy it for 2 months and a day, and I rent it out for 1 month and 30 days, I can still sign an affidavit of a domicile there.
Very good point, because you are occupying for more than 50% of the time that the property is actually to be used, right? So
that is correct.
It's a quirky little 50% of the time of blah, but I think that's important because a lot of us get hung up with how much time is it actually? Well, that's very good. So I would say to our broker community that if if you're on the buying side of things and your buyer is asked to sign this affidavit, you consult a professional, Elana, myself, Isaac, and we will guide you as to whether or not that affidavit can be or should be signed in your scenario. Isaac, you were talking about sales price 300 or under.
Right, but let me just fill in one little dot here.
Sure.
In order to qualify for that residency exemption here, it has to be a natural person or natural persons.
Okay.
It can't be an LLC. Okay, it can't be a corporation. It can't be an LLC. It's got to be en tu propio nombre. It has to be in the name of an individual. Okay.
That buyer cannot be an LLC. So
that is correct. So then throw it out. If they insist on acquiring the property as an LLC, out the window.
Okay. So if our brokers are structuring a sale of a property under 300,000 for a foreigner that could be subject to FIRPTA, they want to find a buyer that is going to buy personally in their name and that will execute this affidavit. That way they could keep their seller out of FIRPTA and still be in complete compliance.
That's correct.
Okay.
So let me tell you. So honestly, like the number one buyer would be a U.S. person with a social security number that can just fill out that form, and you're done with FIRPTA if it's under $300,000. So over $300,000, you're no longer completely exempt. However, if you have an individual that will fit your profile for the residency exemption, and the selling price is over $300,000, between $300,000 and $1 million, the withholding is reduced from 15% to 10%.
Okay.
Right off the bat.
Very, very good point. So now we've got a transaction over 300 and not over $1 million. So from 300 to $1 million, and we've got a seller that does qualify for FIRPTA, but we've got the buyer who also satisfies the residency interest and will execute that affidavit. We go from 15% withholding to 10. Okay.
Right.
Sales price over $1 million, we're at 15%, right?
We're stuck at 15%.
Okay. All
Okay.
right. Yep. I am going to jump us to, I know we've talked about the remittance. I know you mentioned the remittance has to be, when we're remitting, 20 days. And a check is mailed with a form. It's called what, Isaac?
It's called an 8288
Okay.
and accompanied by an 8288A, which which the 8288A is like a little coupon looking form, which is important because that's where the seller will get their, the IRS recognizes their credit for this withholding tax. It's kind of like we get a W-2 form when we work. When they sell this property, they get this little coupon that says, hey, okay, you have $150,000 of federal withholding on account. You need to file a tax return now.
Okay. You know what I want to do? I want to jump into a couple of examples because I learn really well by hearing an example. So I'm going to throw some examples at you, and we're going to talk through them. So Fred is a foreigner. He's selling a property for $1 million. Fred is a citizen of France. He purchased the property for 500,000. So he's selling for $1 million, purchased for 500 10 years ago. We've got gain, okay, between the 5 and the 10. What are our two options? How does that look in real life?
Okay, so we have two options. Either, the simple option is sending the government the money. You do the calculation, 15% of $1 million, like you said earlier, in an example, is $150,000. At closing, along with all the other documents, the notes and the transfer and the deeds and all that kind of stuff, you sign a couple of forms, take a check for 150 grand from the proceeds and send it to the IRS.
Okay. That's one option. The other option is file for the reduced withholding. And how would that look to our?
Well, in this case, based on the fact pattern that we have here, we could do a reduced withholding on or before the closing.
Okay.
And when you take into account the purchase price and the selling price, closing costs, et cetera, et cetera. Well, we really didn't even, I don't think we even talked about closing costs, but it appears that we could reduce it to $100,000.
Okay. All right. Which is so the $100,000 that we would still need to withhold 15% in escrow, correct?
That is correct. And the application is to reduce that while the money's sitting in escrow. The IRS takes our forms and processes it, and with COVID it takes it could take up to 6 months nowadays, and they'll respond with a letter saying, okay, you can release $50,000 to the seller and send us $100,000 instead of sending us $150,000 as originally intended.
Right. So that's in a scenario where a foreign seller has a significant gain on a property. We didn't take into account closing costs or anything, but we're saying there's roughly $500,000 in gain in that scenario. So there will be some form of tax implication, and the way that the U.S. government makes sure that they get that is they're going to put this seller through a FIRPTA process, and that FIRPTA process either has option 1, remit, or option 2, withhold and file for a reduced withholding.
Right.
Am I correct in summary?
You're 100% correct in summary. And I just want to add, my thoughts on a transaction like that would be very, very neutral. I mean, I wouldn't push the client either way, because really the only thing that we're saving him by filing this fairly voluminous application for reduction is having him have the use of $50,000 for an extra 6 months or 9 months or whatever it is, because regardless of which path he takes, remit or reduce, he still has to file a tax return, calculate the tax return, and instead of getting a large refund when he remits, or when he files a return, at the end of the whole process, he'd have a smaller refund to get, at the end of the process, because he'd get a refund. I mean, the way the FIRPTA withholding works is that it's very, very aggressive. Usually the actual tax implications when you do a tax return are much less impactful than these FIRPTA withholdings, even with reductions. So oftentimes people that do a reduction get a further refund.
So that's important for all of us to know, because what you're saying is that at the end of the year, that seller can have you, Isaac, Salver and Salver, file their tax return, right? And then get their, I want the people to know that the 15% is not the tax paid, but the tax might be something different, right? And they'll get a refund from the IRS then?
Right. In Fred's example, I mean, in most scenarios, his tax might be less than 15% of the net.
Of the net.
Of
right.
the net. So, it would be less than 15% of the net. And the way FIRPTA, even the reduced FIRPTA is calculated, it's calculated on a 20% of the net.
Okay.
So there's kind of like a built-in cushion.
Right. So the IRS puts a big burden up front, makes you withhold, or makes you send in a big chunk, and then apply to get your money back, so to speak.
That's correct.
Right. Okay.
That's correct.
All right. We get that. I want to talk about example 2, because I have another foreigner that's selling property for $1 million. His name's also Fred. He's a citizen of Germany. He purchases a property. He's selling for $1 million, but he bought it for 1.1 million. He has not made any improvements. So we don't have gain. We actually have a loss here. And I want to talk about how the impact of in that scenario, the distinction of remitting, which is 150,000, or filing for the reduced withholding is very significant, right?
That's correct. That's correct. That's correct. Because in this case, if Fred, the loser, the losing transaction,
Sure.
Closes a transaction, let's say March 1st, and the money is sent March 1st, 2021 to the IRS, he's really not going to have an opportunity to even file a return until March 1st, 2022, which is 12 months. And then the government, when it comes to foreigners, could take up to 6 months to process his tax return.
Okay.
So, when Fred, in this transaction, when Fred closes and he sends 150 grand of his money to the government, there's a distinct possibility that he won't see that money again until 18 months from the closing.
It's huge.
Okay.
And Isaac, if you were hired to file for Fred from Germany, the one who bought for $1.1 million and is selling now for $1 million, and your advice then, because he's taking a loss, would likely be, we're going to file a reduced withholding for you, right?
Undoubtedly.
Undoubtedly. The money sits in escrow in Becker and Polashuk's trust account. And how long do you think the process is, COVID notwithstanding? What are we looking at until the IRS says no taxes due? Because
let me tell you, the IRS is optimistic because they haven't even changed, their instruction manual, where it says that most applications for reduction will be responded to within 90 days. Okay.
Oh, okay.
They haven't responded in 90 days in over a year now. As a matter of fact, we're still getting, we're getting responses to applications that were filed as early as June and July of 2020. So it's, but we're in constant contact with the FIRPTA unit, and they're kind of repopulating their offices, albeit at 50%. They're still working from home and from the office. It's like a hybrid type of situation. And the supervisor of actually the manager of the branch told us within the last 2 weeks that they're I think a reasonable estimate would be around 6 months now, and hopefully, be becoming shorter as the
Beautiful.
pandemic wanes a bit. It'll be shorter and shorter when, their goal is to respond to these applications within 90 days.
Yeah, and the key in the scenario where Fred is taking an actual loss on the property is that money would not be at the IRS and there for a potential of 18 months. That money would be held in an escrow account, and probably we would get a no tax letter from the IRS that we can release our escrow, and that would come within 6 months. And this Fred would be a lot happier in that second case scenario. So a little bit of planning up front would yield a far better result. Let me move to an example that comes up and that we talked about at the outset of this webinar. ABC LLC is a Florida limited liability company. They're selling a property for $1 million. ABC LLC purchased the property for $500,000 and has not made any improvements. During the listing appointment, our educated agent, Amy agent, believes that the property is owned by a Florida LLC, and that because of that, FIRPTA does not apply. So that's what Amy's thinking. So what does Amy have to know or ask, Isaac, in order to get to the next step? What does Amy agent have to ask that member of that, or that owner of that LLC?
Well, the first and most important questions to ask when you have an LLC, when you have an LLC seller is who owns the LLC, and that's critical. And there are a lot of occasions, Scott and Elana, where the manager of the LLC, the owner of the won't even be sure who owns the LLC. They'd have to do some digging, because a well-planned LLC typically has multiple members. It could be husband and wife, it could be husband, wife, and children, or it could be just an individual person. So one of the first question is, who owns the LLC?
Okay, all right. And really what they're looking for is a determination whether or not that LLC might have multiple member owners or a single member. Like we talked about, single member LLC disregarded, and therefore if that single member is foreign, it passes through and we've got a potential FIRPTA related issue. If we've got two members in an LLC, how does the IRS treat that?
All right, this is where it gets good. Okay. Multi-member LLCs, and I'm going to say this really slowly, and I might repeat it a couple of times because this could be one of the most important points that we're making during this session. Multi-member LLCs are exempt from FIRPTA.
Okay.
Period. They could be owned by 3 foreigners. They can be owned by 1 foreigner and 2 U.S. persons. They could be owned by a foreign corporation, a foreign person, and a U.S. person. A multi-member LLC, regardless of who the owners are, is exempt from FIRPTA.
And why is that?
Because FIRPTA, as we mentioned very briefly in the beginning of our conversation here, is Code Section 1445, which talks about real estate transactions. Multi-member LLCs are subject to a whole nother chapter in the IRS code, which is called 1446.
Okay.
And it has nothing to do with real estate closings, but it has everything to do with the way an LLC itself treats its foreign members. Okay. So the burden is removed from the real estate transaction and shifted to the management of the LLC. And then the LLC has the burden. If there is certain withholding provisions within 1446, they have to comply with that.
Okay. So I think you were telling me earlier that a multi-member LLC is taxed like a partnership, correct?
That it is a partnership.
Okay.
Yes, it's taxed like a partnership unless, like we said earlier, they made an election to be taxed as a corporation, okay, which would also exempt them from FIRPTA.
And does it change if all the members are foreign or if only one member's foreign? Is there any distinction there?
Not that you're going to care about, as you know, as a lawyer in a real estate transaction, or as a title company in a real estate transaction.
Okay, so that's critical. Single member or multi-member is a critical question. Our agents are out in the field. They see a Florida limited liability company as the owner of the property. They get suspicious that that person that they're dealing with might not be a U.S. taxpayer. Their question is, do you know the organization of your limited liability company? Do you know how it's set up? How many members do you have? That's important. If the person does not know, our broker agents out in the field are going to suggest they speak with their tax professional. They call Isaac, they call any of their tax professionals, but especially before or contemporaneously when they're taking the listing, so that these things are not coming up when we're going under contract. That these things are coming up vetted, and their solutions when they are getting their listing appointment and they're going through, you know, signing up a new prospect for a listing, and then our agents look like heroes. So so that's good. The last thing I just wanted to touch on, because I know we're running short of time, is if property is held in a corporation, a U.S. corporation, then the tax implications on that would be it's not subject to FIRPTA, right? Because U.S. corporations they pay tax.
That's correct. That's
and
correct.
And a foreign corporation, we have a lot of foreigners that set property, that hold title to property in offshore companies, Bahamian, Panamanian, Nevis, British Virgin Islands. So in those instances of foreign companies or foreign corporations, then we potentially have FIRPTA related issues.
That is absolutely correct.
Okay. All right. Couple of things. Isaac, I want you to just give us the important items to note. I think there's a few takeaway bullet points that you can just note for the agents at the end. And then I want you to tell everybody out there how they reach you in the event they have a tax related question. I'd like, you know, for you sharing your time, which we're so grateful for, I'd like people to know how to get in touch with you. Obviously, we're going to send out information on your firm, but you could say it now after you give the importance to note.
Okay, so there's a few things that, you know, we like to tell agents when they get a listing. Ask questions about your seller's citizenship, which is very, very important. And if you find out through conversation, if the individual is a non-resident or their residency is in question, then you should immediately, a light should go on in your head. Okay, this, we might need to engage a CPA right from the onset. It's very, very important. And another thing to note is what Elana talked about regarding the contract process. And she brought up those provisions with Roman numerals. I like to look at those provisions as line 551. Line 551. If you're representing a seller and you have not inked the final contract yet, like Elana said, by crossing out a few simple words, you could put your client, the seller, in the driver's seat regarding any of these options on how to handle the FIRPTA, either remitting or applying for an exemption from the FIRPTA. And then, of course, we as CPAs have different checklists that we can provide for you regarding FIRPTA transactions, and you can call us. We're on the net. You could look up Salver and Salver. Our website is Salver. I'm sorry. Our website is www.salver.com. It's just as easy as that. As long as you remember Salver, you'll be able to find us, because our domain name is salver.com.
SALVER, correct?
SALVER.
Okay.
SALVER.
All right, that's perfect, because what I'd like to do for all those that registered, We're going to be sending out, we have information to send. We could send out FIRPTA checklists. Elana, any parting thoughts? I think, Elana really manages Becker Title for the law firm, and she's done such a phenomenal job. She converted the name when that it used to be. We won't even mention the prior name, but because now we're Becker Title. So Elana manages the title company. She does an absolutely phenomenal job. It's day in, day out, 24/7, right, Elana?
Yeah,
I mean, it's just nonstop. Yeah.
It's been pretty crazy right now for all the agents and for us, which has been great. Just a clarification, I guess. When a seller is foreign, it's really not even optional to engage a CPA or not. We, as the attorney, as the title company, do not prepare any tax forms. We don't prepare 8288s. So that's really on the CPA and the seller to provide us with those forms. So it's not even really an option. It's a requirement. You got to engage Isaac, or if the seller already has a CPA, their CPA.
I love that point, because we're in the midst of a transaction and we get asked, well, can't you, Scotty, Elana, can't you fill out these forms for us? These are tax forms. Yes, I can fill out a form, but it's a tax form, and I prefer that the professionals do it. And that is the edict of our title company, and us even as lawyers. We prefer that the professionals, the tax professionals, fill out their forms. They went to school for it. Let them do it. Guys, this has been a first great kickoff of 5 more to come. This is a half a dozen multi-part series. So we're excited. And thank you, Isaac. We thank you from the bottom of our hearts. We're very grateful.
Before we sign off, could I just, first, I want to thank you. I'm grateful that you allowed me to be like the leadoff batter for this series. I mean, you guys have an awesome marketing staff headed up by Laura Benson and Evelyn Benjamin. They did a fantastic job. Scott, you did a great job, because, you made me feel really, really comfortable. I think we got the information out there in a very digestible, usable way. I guess between us, we're just a quiver. I mean, we're an arrow in the quiver of an agent's, arsenal of tools. And, we encourage everybody to use it. And Elana, I just want to thank you for, for everything that you contributed and everything that you do. So I'm very, very grateful for the opportunity.
Thank you so much, Isaac.
Thank you, Isaac.
Thank you.
Bye.